Good day everyone, this is Jillian Bularin from Group 2 and I will be presenting the part 1 of Chapter 7, Provisions Common to Liquidation in Insolvency of Individual and Juridical Debtor. In this chapter, we will be delving into the core components that govern the process of liquidation in cases of insolvency applicable to both individual and juridical debtors. This comprehensive framework encompasses various crucial aspects including the liquidation order, which encompasses sections 112 to 114, and next we have the liquidator from sections 115 to 122. Next, the termination of claims from sections 123 to 126. Avoidance proceedings, sections 127 to 128. Next, the liquidation plan encompasses the sections 129 to 135. And lastly, the liquidation of a securities market participant, which only encompasses sections 136. Section 111. Use of term debtor. This section clarifies the usage of the term debtor within Chapter 7 of the Act, which encompasses provisions common to the liquidation process in cases of insolvency involving both individual and juridical debtors. In this context, debtor refers to an individual debtors as defined in Section 4.0 and debtors as defined in Section 4.k of the Act. This section ensures consistency and inclusivity in the application of the term throughout the chapter, irrespective of the type of debtor involved in the insolvency proceedings. Section 112. Liquidation Order. This section outlines the provisions of the liquidation order in cases of insolvency. So first, declaration of the debtor's insolvency. B. Ordering the liquidation of the debtor, and if the debtor is a juridical entity, declaring it dissolved. C. Directing the sheriff to take possession and control of all the debtor's property, except those exempt from execution. D. Ordering the publication of the petition or motion in a newspaper of general circulation for 2 consecutive weeks. E. Directing payments of any claims and conveyance of any property due to the debtor to the liquidator. F. Prohibiting payments by the debtor and the transfer of any property. G. Directing all creditors to file their claims with the liquidator within a specific period. H. Authorizing the payment of administrative expenses as they become due. I. Stating that the debtor and non-petitioner creditors may submit nominees for the position of liquidator. J. Setting a hearing date for the election and appointment of the liquidator within a specified time frame. These provisions establish the framework for the orderly liquidation of the debtor's assets and the fair treatment of creditors during the insolvency process. Section 113. Effects of the liquidation order. Upon issuance of the liquidation order, the following effects take place. A. Juridical debtors are dissolved and their corporate or juridical existence ends. B. Legal title and control of all debtor assets, except those exempt from execution, are vested in all the liquidator or, if not yet elected or appointed, with the court. C. All contracts of the debtor are terminated or breached by default unless the liquidator, within 90 days of assuming office, declares otherwise and the contracting party agrees. D. No separate action for the collection of unsecured claims is allowed. Pending actions are transferred to the liquidator for acceptance, settlement, or contestation. If contested, The court resolves such disputes except when already on appeal, in which case the case may proceed to judgment. E. Foreclosure proceedings are prohibited for 180 days. These effects ensure the orderly administration of the debtor's estate and protect the interest of both the debtor and the creditors during the liquidation process. Section 114. Rights of secured creditor. Section 114 specifies the rights of secured creditors following the issuance of the liquidation order. So, first, the liquidation order does not affect a secured creditor's right to enforce their lien according to the contract or applicable law. And second, a secured creditor has the option to, first, waive their right under the security or lien, prove their claim in the liquidation proceedings, and participate in the distribution of the debtor's assets, or maintain their rights under the security or lien. If the secured creditor chooses to maintain their rights under the security or lien, the following options are available. The value of the property may be determined by agreement between the creditor and the liquidator. If the property's value is less than the claim it secures, the property may be conveyed to the secured creditor, who will then become a creditor for the balance in the liquidation proceedings. If the property's value exceeds the claim secured, the excess may be received by the liquidator after conveying the property to the creditor. Next option, the liquidator may sell the property and use the proceeds to satisfy the secured creditor's entire claim. And last option, the secured creditor may enforce the lien or foreclose on the property in accordance with applicable laws. These provisions ensure that secured creditors have options for the treatment of their claims and the realization of their security interest in their debtors' assets during the liquidation process. Section 115. Election of liquidator. This section delineates the process for electing a liquidator in insolvency proceedings. It stipulates that only creditors who have filed their claims within the court's set period and whose claims are not barred by the statute of limitations are eligible to vote. Secured creditors, typically excluded from voting, may do so if they either waive their security or lien or agree with the liquidator on the value of their secured property and are admitted for the remaining claim balance. Eligible creditors participate in an open court elections to choose the liquidator. The nominee who receives the highest number of votes based on the amount of claims and meets the qualifications outlined in Section 118 is appointed as the liquidator. This process ensures that creditors with valid claims have a say in selecting the individual tasked with administering the liquidation proceedings. By allowing only eligible creditors to vote and employing a transparent election process, the section aims to maintain fairness and integrity in the appointment of the liquidator, thereby safeguarding the interest of all parties involved in the insolvency proceedings. Section 116. Court-appointed liquidator. This section outlines circumstances under which the court may appoint a liquidator. A. If on the designated date for the election of the liquidator, creditors do not attend. B. If attending creditors fail or refuse to elect a liquidator. C. If a duly elected liquidator fails to qualify. And D. If a vacancy in the position of liquidator arises for any reason. In any of these situations, the court may schedule another hearing for the election of the liquidator. Additionally, this section clarifies that a rehabilitation receiver who previously administered debtor who administered the debtor before liquidation proceedings commenced may be appointed as a liquidator. This provision ensures that the liquidation process can proceed smoothly even if creditors fail to elect a liquidator or if circumstances require a replacement. It also allows for continuity by permitting a previously appointed rehabilitation receiver to transition into the role of liquidator if appropriate. Section 117. Oath and Bond of the Liquidator. This section mandates that before assuming their powers, duties, and responsibilities, the liquidator must undertake two key requirements. So first, taking an oath. The liquidator must take an oath, affirming their commitment to fulfill their duties faithfully and responsibly. And second requirement, filing a bond. Additionally, the liquidator must file a bond with the court. The bond's amount is determined by the court and is conditioned upon the proper and faithful discharge of the liquidator's powers, duties, and responsibilities. These measures are put in place to ensure that the liquidator carries out their obligations diligently and in accordance with the law, providing reassurance to creditors and stakeholders involved in the insolvency proceedings. Section 118. Qualifications of the liquidator. This section outlines the qualifications necessary for a liquidator. So, the liquidator must meet the qualifications enumerated in Section 29 of the Act. These qualifications include being a citizen of the Philippines or resident of the Philippines for the 6 months preceding their nomination, of good moral character, possessing acknowledged integrity, impartiality, and independence, knowledgeable about insolvency and relevant commercial laws, rules, and procedures, with the necessary training and/or experience to discharge the duties of a liquidator effectively. And lastly, is free from the conflicts of interest, although such conflicts may be waived by a party who may be affected. Additionally, the court retains the authority to remove the liquidator at any time for cause, either on its own initiative or upon motion by any creditor eligible to vote for the liquidator's election. These qualifications ensure that the appointed liquidator is competent, ethical, and capable of impartially executing their duties, thereby safeguarding the integrity of the insolvency proceedings and protecting the interests of all parties involved. Section 119. Powers, duties, and responsibilities of the liquidator. So again, this section outlines the extensive powers, duties, and responsibilities of the liquidator in insolvency proceedings. So first, preserving and maximizing asset value. The liquidator is tasked with preserving and maximizing the value of the debtor's assets to facilitate the recovery and discharge as much of the debtor's obligations as possible. Next, asset recovery. The liquidator has the authority to sue and recover all assets, debts, and claims owed to the debtor. Asset management. They are empowered to take possession of all debtor property except those exempt by law and to sell such property with court approval. Next, debt settlement. The liquidator is responsible for settling accounts between the debtor and creditors subject to court approval. Next, fraudulent conveyance. They are authorized to recover any property of its value that was fraudulently conveyed by the debtor. Next, creditor committee. The liquidator can recommend the court the establishment of a creditors committee to assist in their functions. Next, engagement of professionals. With court approval, the liquidator can engage professionals to aid in their duties. Maximizing asset proceeds. the liquidator is obligated to manage and dispose of the debtor's assets in a manner that maximizes proceeds for creditors and shareholders, ultimately leading to the termination of the debtor's legal existence. Additionally, the liquidator can be removed following procedures similar to those for removing a rehabilitation receiver. These powers and duties underscore the critical role of the liquidator in efficiently managing the insolvency process, realizing asset value, and ensuring equitable distribution to creditors and stakeholders. Section 120. Compensation of the liquidator. This section addresses the compensation of the liquidator and in individuals or entities assisting them in fulfilling their duties. Reasonable compensation. The liquidator and those assisting them are entitled to reasonable compensation determined by the liquidation court. Prescribed maximum amount. So the compensation awarded to the liquidator and their team cannot exceed the maximum amount set by the Supreme Court. This provision ensures that those involved in the insolvency proceedings receive fair compensation for their services while also preventing excessive remuneration. It strikes a balance between recognizing the value of their contributions and ensuring that resources are appropriately allocated during the liquidation process. Section 121. Reporting requirements. Reporting requirements for the liquidator in insolvency proceedings. Record keeping. The liquidator is responsible for maintaining a record of all funds received and disbursed by them or under their authority as liquidator. Quarterly reports. They must submit quarterly reports of these financial transactions to the court. These reports are to be made available to all interested parties involved in the proceedings. Additional reports. The liquidator is also obligated to submit any other reports as may be required by the court periodically. Additionally, they must provide a final report at the conclusion of the liquidation proceedings. These reporting requirements ensure transparency and accountability in the management of funds during the insolvency process. They provide stakeholders with regular updates on the financial status of the proceedings, promoting trust and confidence in the liquidator's actions. Section 122. Discharge of the liquidator. So in this section describes the process for the discharge of the liquidator in preparation for the final settlement of claims against the debtor. The notifications to creditors. The liquidator is required to notify all creditors of their intention to settle their account and seek discharge from liability as the liquidator. This notification can be done through publication in a newspaper of general circulation or through any other mode directed or allowed by the court. Final accounting. The liquidator must file a final accounting with the court accompanied by proof of notice to all creditors. Hearing. The final accounting is then scheduled for a hearing. And lastly, discharge. If the court determines that the final accounting is in order, it will discharge the liquidator from their duties and liabilities. This process ensures that the liquidator's actions are reviewed by the court, creditors are informed, and appropriate steps are taken for the final settlement of claims against the debtor before the liquidator is discharged. Section 123. Registry of Claims. So this section establishes the creation of a registry of claims by the liquidator. Preliminary registry of claims. Within 20 days of assuming office, the liquidator must prepare a preliminary registry of claims. This registry encompasses both secured and unsecured creditors. Treatment of secured creditors. Secured creditors who have waived their security or lien or have agreed with the liquidator on the value of the secured property and are admitted as unsecured creditors for the remaining balance are treated as unsecured creditors in the registry. Public inspection and notice. The liquidator is required to make the registry available for public inspection and provide notice of publication to creditors, individual debtors, partners of partnership debtors, and shareholders or members of corporation debtors. This notice informs them where and when they may inspect the registry. And lastly, claims verification. All claims listed in a registry must be duly proven before they can be paid. This section ensures transparency in the insolvency process by allowing stakeholders to access information about the claims against the debtor. It also establishes the procedures for verifying and addressing these claims, contributing to the orderly administration of the insolvency proceedings. Section 124, Right of Set Off. So this section addresses the right of offset in insolvency proceedings. Mutual debts. If the debtor and creditor owe each other money, their debts can be set off against each other. Balance consideration. Only the balance, if any, remaining after setting off the mutual debts will be allowed in the liquidation proceedings. This provision ensures fairness by preventing a situation where both the debtor and creditor are simultaneously owed money, which could complicate the resolution of claims in the liquidation process. Instead, it streamlines the process by allowing the net balance to be considered in the proceedings. Section 125. Opposition or challenge to claims. Submission of challenge. Within 30 days after the deadline for filing applications for the recognition of claims, interested parties such as creditors, individual debtors, owners of sole proprietorships, partners of partnerships, and shareholders or members of corporations may submit a challenge to a claim or claims to the court. Notification. A certified copy of the challenge must be served on both the liquidator and the creditor holding the challenge claim. Submission of registry of claims. Upon the expiration of the 30-day period, the rehabilitation receiver or the liquidator is required to submit to the court the registry of claims containing undisputed claims that have not been challenged. Finalization of claims. Claims listed in the registry that have not been subject to challenge become final upon the filing of the register. Subsequently, they may only be set aside on grounds of fraud, accident, mistake, or inexcusable neglect. This section ensures a mechanism for resolving disputes regarding claims in insolvency proceedings, allowing interested parties to challenge claims they deem invalid or inaccurate. It also provides a time frame for the finalization of claims, promoting the efficient administration of the liquidation process.